believe within a day or two of the deposition on August 11th.
Okay. And so you did depose the expert about that map yesterday?
Yes, and I had asked him about what he was working on or what he had prepared on August 11th, and I was satisfied that we had discovery of that, the defendant's mapping.
Okay. Okay, and so then you became aware of what?
Well, yesterday, counsel had indicated that there were no maps that were prepared, additional maps.
Well, specifically, what he said, and I just had the court reporter pull the transcript. So Mr. Climate says that, he says, begins at just page 21, line 20. It's not one response, but several emails back and forth, and Ms. Doherty and I were on a Zoom together discussing this issue on the phone, one of the two, or on the phone, one of the two, so that's a misrepresentation. In addition to that, there are maps that he said he would create for the other individuals, like timing maps. It shows the trajectory of where they were at certain particular points in time during the course of this conspiracy. He did not create the maps, and so we're not using the maps. So whatever he's testifying to comes from the evidence, comes from the cell phone extraction, right? That's what he said. And let me look here. And then I said, I know, but if it's an expert opinion, specifically, is he going to testify to anything regarding the cell phones of the co-defendants? And Mr. McClymonds said yes, but he doesn't have to provide a map for that. And then I said, I'm not saying that. They're saying that they asked you about that and that you didn't respond. Mr. McClymonds said, well, I just said that's not true. He didn't say I did not respond. He said I responded one time. That's not true. I responded a few times back and forth. That conversation was just about whether I was going to produce these interactive maps, and I told him I don't have them. And then I asked Mr. Harmon, did you depose him? Mr. Harmon said, I did, Your Honor, and I asked him if he had developed any further opinions or other work to let us know. We could take a deposition of him, and I reserved the right to continue the deposition. So, and then I said, and were you ever notified after the deposition that their expert was now going to offer opinions as to the cell phone data of the co-defendants? And Mr. Harmon said no, and I said until today. He said, and Mr. Harmon said no, and I said the middle of the trial, and Mr. Harmon said yes, and then Mr. McClymonds said there's a difference between him offering an opinion about, and then basically I said, listen, we've got to get going, we'll cross that bridge at a later date. State you need to file whatever appropriate motion you deem necessary regarding that. Okay? So, are you intending to produce any maps that were not already produced to the state?
No.
Okay. So there's no additional exhibits other than the one you've seen?
Yes, but there's a whole other issue because I deposed this witness last night at 5 o'clock. I accommodated his time, 5 to 5:40 was the available time I had. He indicated that he has prepared, and I put this in my motion, 4 additional, or 4, not additional, but 4 reports. Reports dealing with the iCloud. And I put in this motion quotes of this witness when I asked him in the deposition back in August if he intended on creating anything from the iCloud or any other evidence other than maps, and he indicated no. So we didn't know anything about any reports being prepared. So he told us last night he has prepared 5 reports. 2 of them were prepared in late August, August 29th and August 30th, provided to the defense. And then the last one was prepared the day before yesterday. He had finished preparing that, or the last 2, I believe. So I delineated in my motion what those are, but they are basically PDF format reports dealing with the defendant's iCloud account, Mr. Gathwright's iCloud account, messages between the two, that have been collated into these PDF format reports that are multiple page reports. One of them's 18 pages. The one that was completed on August 29th is a 32-page PDF, including 32 messages from June 23rd of 2024 between Gaithright and the defendant. The one on August 30th is an 18-page that was completed by the expert on August 30th. It's an 18-page PDF report containing photographs, contact information, text messages, sent via some type of communication application on different dates, and was compiled from the defendant's iCloud account information. The one that was the report that he completed on October 28th is a 3-page PDF containing screenshots from CDR records and FaceTime calls between Mr. Gaithright and the defendant, compiled from the iCloud account information. And then the last report that he completed was a conversion of the Celebrite iCloud information to PDF Adobe format. We have not been provided these or alerted to their existence, and that is the subject of my motion.
So there was a report that was dated August 29th. Is that correct, Mr. McClimate?
So the word report is sort of confusing. As I explained yesterday, these are not reports that he creates with an opinion. This is not something that he writes about the evidence. They are extractions from the different devices, so like an Axiom or Celebrite. For Alicia's iCloud, Alicia Andrews' iCloud, there are 370,000 artifacts in there. If you want to just look at or isolate text messages from a certain time period, you can go in there, you can click certain items that you want, you can press generate report, and it'll show you those items on a PDF. They're not reports in the sense that I believe the state has the understanding of. They're not those type of reports.
All right, well, let's take a look at the rules of discovery, okay? Rule 3.220, Rules of Criminal Procedure, which lays out the defendant's obligations at subparagraph D, subsection 1. If a defendant elects to participate in discovery, the following disclosures must be made. And then subsection B of 1. Within 15 days after receipt of the prosecutor's discovery exhibit, the defendant must serve a written discovery exhibit which must disclose to and permit the prosecutor to inspect, copy, test, and photograph the following information and material that is in the defendant's possession or control. Subsection 1, the statement of any person listed in subdivision D1A other than that of the defendant, and 2, reports or statements of experts that the defendant intends to use as a witness at a trial or hearing made in connection with the particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons. So you're telling me that what he prepared doesn't qualify under 3.220 D1B2. Is that what you're telling me?
If that's the section that refers to reports that the defense intends to use at trial, then that's correct. For 2 reasons. 1, because it's not a report, and 2, because I don't intend to use the documents that he's referring to in trial. So it does not fall under our reciprocal discovery obligation.
It doesn't say you have to intend to use it at trial. It just says reports or statements of experts that the defendant intends to use as a witness at a trial. It doesn't say you have to use the report at trial. It just means a report generated by the expert you intend to use at trial. So were these not reports generated by an expert you intend to use at trial? Well, I think they are.
How would you know that if you don't know what I'm going to ask him on the stand?
Because they're reports that were generated by your expert. This actually isn't tricky. I don't see this as being difficult. So they're also under subsection J, continuing duty to disclose. If subsequent to compliance with the rules, a party discovers additional witnesses or material that the party would have been under a duty to disclose or produce at the time of the previous compliance, the party must promptly disclose or produce the witnesses or material in the same manner as required under these rules for initial discovery. This duty includes any additional recorded or unrecorded statements of any person disclosed under subdivisions B1A or D1A of this rule that materially alter a written or recorded statement previously provided under these rules. So what are you asking for, Mr. Harmon?
Judge, the term report is the witness's term from the deposition. That's not the state's. He indicated he prepared reports and then he described them as reports. So, well, it sounds like counsel's saying they're not going to utilize these through his testimony. That's fine. We're going to move to exclude them, have the court exclude use of the reports and the information contained. But I would ask that the expert be not allowed to testify to anything from those reports if they're not going to be provided to me to utilize in cross-examination. And now at this point, like indicated in the report, if they're going to have them testify to something that's contained in the report, we haven't had a chance to properly prepare for cross-examination.
The documents, it's documents in the report, they're PDFs from the state's discovery. They are PDFs. All they are is an extraction of the very evidence that was turned over to us by the state.
So then why do you object to him reviewing it?
I never objected to him reviewing the exhibits.
Okay, then great.
The reports or
Great.
the PDFs.
Then just produce it. Then just produce it.
I don't have a problem with that. He never said, hey, can you give me the reports? Just filed the motion.
Okay.
I was filed the witness.
Okay, so do you have the, whatever the witness, and is his name Pullen?
Pullen, P-U-L-L-E-N.
Okay. Whatever Mr. Pullen referred to in his deposition as far as reports that he used on the dates in question, any and all reports, but just to make sure we're all on the same page, August 29th, August 30th, October 28th, and was there another date, Mr. Harmon, you're aware of?
Yes, August 29th, 30th, and October 28th.
Okay, so any and all reports referenced in the expert's deposition need to be disclosed to the state before he testifies. Do you have those available here?
He's outside, so I'm going to have to email it. And honestly, the 4 reports that he's mentioning, these are, again, reports that he created. I don't even know that he gave them to me. They're just to assist with displaying information that is in the axiom and in the cell record.
Okay, let's bring them in here. I'm just going to tell him to email them to you. Okay? That way you have them, and so he can't testify until the state's had a chance to review that evidence. So, and then state, when the jury comes in, are you going to rest?
We are, Judge.
Okay.
Yes, ma'am.
So, let's go ahead and do GOA motions before the jury comes in. So,
Judge, is there a lineup of witnesses this afternoon from the defense?
So we got Robert Howard first, likely Tom Fuller second. Not sure the exact order, but it's going to be Simone Lyles, Kayla Robinson, Joelle Jordan, Anthony Lala.
okay, well, the expert's going to have to get pushed to the end, because the state's got to have time to look at whatever the reports are, whatever he generated, okay?
That's fine, Judge. When they see the reports, the PDFs, they're probably going to realize that it's not really.
Okay, that may be true.
Judge, the order of witnesses brings up another issue. We filed motions in limine dealing with the issue of coercion and domestic violence.
Right, that's not coming in unless the defendant testifies. The only thing that's relevant as far as her relationship with Mr. Chance is on the day of the incident. That's it.
So I do want to argue on that. During,
Hold on one second, let's skip. Hi, are you Mr. Pullen?
yes, ma'am.
Hello, Mr. Pullen. So I think you were deposed yesterday by the state, and you indicated during your deposition that you had prepared what you referred to as reports on a number of dates. Yes?
Yes, Your Honor.
Okay. So the state has not seen those yet. So Mr. Harmon's going to give you his email address, and I need you to email him everything, every report that you produced in this case before you testify, okay?
Yes, sir.
Okay, they're going to hand that to you. No, I have so much paper here. I don't even know. Okay, very good. That's handled. So let's talk about, Mr. McClymonds, let's go ahead and deal first with the JOA issue. Let's just, so we don't have to send the jury back out again. Are you making a motion for JOA?
I am.
Sure. Tell them we'll be right with them.
Yes, Judge.
You're good. I know you're fine, because I'm going to tip over, and then all my paperwork will work. Okay, Mr. McClymonds, you ready to go?
The defense moves for its first motion for judgment of acquittal, recognizing that the standard at this stage of the case is that all the evidence is to be held in the light most favorable to the state. The state does have to prove a prima facie case in this case of all the elements of the two charges, which are first-degree murder and conspiracy to commit first-degree murder. In this case, Alicia Andrews is not charged as a shooter. She's charged by indictment as a principal to the murder of Charles Jones. The state presents a circumstantial case here, circumstantial claims against Ms. Andrews to prove first-degree murder charges against her as a principal. Ultimately, the evidence that was presented shows nothing about Alicia Andrews intending or knowing that the individuals who ended up shooting and killing Mr. Charles Jones, or even individuals that planned it, there's no evidence that shows, direct evidence that shows that she knew that was going to happen, that she planned it with these individuals, that she discussed it with these individuals. There is only circumstantial evidence that has her at or around the scene, only circumstantial evidence that has her at or around people who are making phone calls to other people at times that don't connect, at times that the state is assuming there were connected calls and there were conversations being had back and forth with individuals, with their co-defendants. In Staten versus State 519 Southern 2nd, this is 622 at 624. It's a Florida Supreme Court case from 1988. The Florida Supreme Court acknowledged the general rule that in order to be convicted as a principal for a crime physically committed by another, one must intend that the crime be committed and do some act to assist the other person in actually committing the crime. See also the Florida Statute 777.011 and Collins versus State 438 Southern 2nd 1036. It's the second ECA case from 1983. The Staten Court noted that neither knowledge that the offense is being committed, nor mere presence at the scene, nor a display of questionable behavior after the fact is equivalent to participation with criminal intent. And that's at 624, page 624 of the Staten case. It is, in the defense's view, undisputed that the state does not have any direct evidence that Ms. Andrews knew of her co-defendant's plans. It's also undisputed that the state does not have any direct evidence that Ms. Andrews agreed to cooperate with the efforts to kill Charles Jones in this case. There's no written communication between Ms. Andrews and her co-defendants or anyone that would show she intended to kill Charles Jones during the times laid out in the indictment in this case. There is no confession, and there are no witnesses that would testify to that fact. Alicia Andrews did not have a motive to kill Charles Jones. There was this back and forth war that the state has put on for the entirety of this case, where individuals are shooting at each other, killing each other, rapping about it, and Alicia Andrews is not in any of the rap videos. Alicia Andrews is not personally or deeply connected to any of the individuals who died, and Ms. Andrews herself was never brought up in any of these rap videos, was never brought up in any of these back and forth arguments and whatnot with the individuals that she's being tried with, or not necessarily tried with, but that she's being indicted with. They, on the other hand, have different issues and different motives to kill. Alicia Andrews apparently has none, other than what the state posits as her relationship with her boyfriend at the time. Ms. Andrews is not a gang member or a gang affiliate, as testified to by all of the witnesses in this case. And again, the state's case is purely circumstantial. To prove that Alicia Andrews is a principal to the murder of Mr. Jones, the state must prove that Alicia Andrews aided and abetted her co-defendants. The evidence shows that Alicia Andrews was someone that was taken advantage of, someone who did not know to conceal her face or her identity from an Airbnb camera in the front door, someone whose phone was used primarily throughout the conspiracy and throughout the plot, like really against her knowledge that they were doing these things. There's no evidence that she knew that they were doing these things behind her back. The evidence shows that she was not with the defendants when they were packing bags or packing the cars to leave Jacksonville to come to Tampa, that she was at her house. She was then picked up after all of that planning was done, put in a car, and went to Tampa. There's also, I guess, this idea that the defense has said that at some point Alicia Andrews was going on a romantic getaway, and that is not what the defense ever said.
That's what was said in opening statement, because I wrote it down.
It was not.
It was a weekend of, quote, reckoning and reconciliation, close quote.
Right, that's not romantic. So, as you see from the evidence, on June 17th of 2024, there was argument back and forth with Isaiah Chance and Alicia Andrews. And after that, a few days after that, they do go to Tampa. So our statement in opening statements that this was a weekend of reckoning and reconciliation is consistent with the evidence. There was no romantic getaway. That language comes from Detective Ramos during the interrogation, where he says and uses the word romantic getaway. Alicia Andrews never says those words in her interrogation.
Okay, well, let's just stay focused on the JOA motion.
All right. When the state relies on aiding and abetting theory, it can prove intent either by showing the defendant had the requisite intent herself, or that she knew the principal had that intent, so that she knew that the other individuals had an intent to do these things. And again, there's no evidence of that. This case, being that it's clearly circumstantial, is one that the state needs to exclude every reasonable hypothesis of innocence that Ms. Andrews intended to be a part of the criminal activities, and for the reasons that I've stated previously, there's not enough evidence for the state to prove by a prima facie case that Ms. Andrews knew what was going on, or that she intended to participate, or that she aided and abetted in any way.
Okay, state what's your response.
Judge, we have more than circumstantial evidence in this case, and we have more than merit burden. Not only is there circumstantial evidence, there is direct evidence, video evidence of this crime. We have the defendant as an active participant. She is at multiple locations. She is seen on video at teasers with co-defendant Isaiah Chance, along with the evidence, the surrounding video. We know exactly what occurred in this instance. Her and Isaiah Chance were in one vehicle. They clearly were the tracking vehicle. They both can be seen getting out. She is on video at one point when the phone goes, when the phone password gets activated. She has to access that phone for him, so she's close enough to him at all times in the car. When they are walking, she knows exactly what is going on. There is video evidence of that, of her and Isaiah Chance and what they do in the silver Chevy Cruze and the coordination that goes on with the black Chevy Impala, not at one location, not at two locations, Your Honor, but at 3 locations. And she admits, so there are admissions in this, not that she did anything, she never admits her guilt, but she admits that that is her. So there is no doubt that that is her, that is caught and captured on video. We have video footage about how well planned and how coordinated this premeditated murder was. So there is ample consciousness of guilt evidence in this case as well. Any action on her part to evade and avoid prosecution, to evade law enforcement, there clearly are messaging on her phone, and there is a very significant relevant period of text messages that are missing from her phone, and there are messages after this crime occurs where she is messaging some friend about how law enforcement has the wrong phone, and she puts LMFA, that, excuse my language, laughing my fucking ass off, that the police have the new phone, not the old phone. So clearly that is a consciousness of guilt, statements made that she knows that there is something on the phone that law enforcement does not have. And this is a whole conversation that she is having with the friend at the same time when she knows police are at her home. So Judge, there is ample evidence of her guilt, her consciousness of guilt in this case, her multiple lies to law enforcement in that interview where she says that she does not know who the victim or is not familiar with Julio Foolio, Charles Jones, where she claims ignorance of her boyfriend's rapper name in this gang war, which is Gutta, which we have shown that is tattooed on her body well before this incident happened. There is ample messaging to other people, to good friends, Jordan, where she displays her personal animosity of the victim in this case, including whether or not, she can qualify it as anything she wants. She is talking about very personal events in her life, where a person with the nickname of Spaz, who was killed in this gang rival war by Mr. Jones's side, and that there have been drill rap videos on it, and she certainly in that conversation was showing a personal animosity to the victim in this particular case. So there is direct evidence of what her active participation was, which includes booking the Airbnb. And that is the first date that we allege the conspiracy begins. It probably began well before that. But the her actively trying to book an Airbnb here in Tampa for all of these killers to come to Tampa for the specific purpose of killing Charles Jones is one of the first acts that we can document of her participation in the conspiracy. You heard from Detective Ramos that Charles Jones' phone and device was nowhere near. It was miles away when she did this. and she is booking it through a third party. And in that interview with law enforcement, when they first asked her, she says no. Again, she is lying. That is consciousness of guilt. It is not until they tell her that we have the phone messaging where she finally admits to that. So based on all of the facts and all of the evidence, we clearly have met our burden, and we have gone beyond that burden. The evidence in this case is overwhelming, and we'd ask that you deny their motion for JOA at this time.
Okay, I will deny the motion for JOA. So with regards to, we've had multiple discussions about the victim's state of mind. I'm going to repeat that there is no defense of duress in the state of Florida for homicide. And that's stated explicitly at Corojo, C-O-R-U-J-O versus State 424 Southern 2nd 43. Second DCA said, coercion is a recognized defense to a criminal charge except where an innocent life is taken. There is one case out of the third DCA, Wright versus State, and I think we've discussed this previously. The third DCA reiterated there's no duress defense in an intentional homicide case or any homicide case whatsoever. And in fact, that's at 402 Southern 2nd 493, 1981 third DCA case. And that court stated Florida has recognized the common law defense of duress as a defense to crimes other than homicide. Okay? The common law has steadfastly refused to recognize any compulsion, even the threat of death, as sufficient to excuse taking the life of another. Legal recognition of duress as a defense to crimes other than homicide necessarily assumes a working hypothesis that a harm or crime of greater magnitude is avoided when the subjected person succumbs to the duress. So duress is not a defense in a homicide case. However, in the same opinion, the court did discuss duress as negating state of mind. And specifically, that court stated, having decided that duress is not a defense to the intentional killing of another, we now address the question of whether evidence of duress, even though imperfect, which serves to show that Wright did not act with a premeditated design to kill the victim or with a depraved mind, requires us to produce the defendant's conviction for second-degree murder to a conviction for manslaughter. The answer to this question depends in our view on whether the person, such as the defendant, who aids and abets another in the commission of a murder, must herself be shown to have the state of mind required for the homicide. Because we find the rule in Florida to be that aiders and abettors may be convicted either upon proof of their own state of mind or upon proof that they knew that the person aided had the requisite state of mind, evidence that the aider and abettor knew that the principal had a premeditated design to kill or a depraved mind, will support the aider and abettor's conviction for first or second degree murder. And essentially, in that case, the court seemed to open the door to at least the possibility that some type of threat or harm could be admissible to go to the defendant's state of mind, okay, which is why I ruled initially the way that I did. And I told you guys then, I said, listen, you can get up in opening statements and you can make this point, but this only comes in if the defendant testifies, because all that's relevant is her state of mind on the date of the offense and why she did or didn't do something. Nobody can come in here and extrapolate and say, well, they used to fight a lot and he would beat her up and therefore she must have been scared. That's inadmissible. It's irrelevant. So, and as I indicated, if the defendant testifies, and if she testifies that there were issues of domestic violence between her and Mr. Chance, and that's why she was in fear, and if the state cross-examines her to the point that it appears they're challenging whether that domestic violence actually occurred, then the door would be open for the defense to call other witnesses to support that. At this time, there's nothing in the record that she was in fear of anything, nothing to do with her state of mind. So, okay?
For the record, the defense has never requested to use duress as a defense in this case, because I also am aware of the case law. I've never asked for a duress jury instruction. I do not intend to ask for a duress jury instruction. What we asked for was to show the previous abuse, to show Ms. Andrews' state of mind in this case. which is very relevant in a first-degree murder case. That is what we asked for from the beginning. This was never I want to put up domestic violence as a defense to the first-degree attempted murder, first-degree murder and conspiracy to commit first-degree murder. That was never our position. In this case, Ms. Andrews, and what the state has done on redirect of Detective Ramos, is ask him, show him text messages of Alicia yelling or cursing at Isaiah Chance, her former boyfriend, in an aggressive manner, and asking Detective Ramos, does it look like Ms. Andrews was afraid of Isaiah Chance a week before? This is not the day of, it's the week before. They've asked that question. So in my view, they've opened the door to any of this stuff to come in. They've made it relevant. Her state of mind, whether she was afraid of Mr. Chance. So that is one issue to decide. The second thing is, if it is relevant, which it is, Mr. Andrews' state of mind, that evidence should not be blocked and only filtered through Ms. Andrews. Of course, another witness cannot speak to an individual's state of mind, but they can speak to the incidents that they have been a witness to, and they can speak to the abuse that she suffered. They just cannot make the connection to say that because she was a part
But
of...
if they can't make the connection, then why should they be able to testify to it? If they can't make the connection, why is it relevant? So then are you going to stand in front of the jury and make the argument, we'll extrapolate jurors, even though we don't have any evidence in this case that she was scared, you need to extrapolate what these witnesses said, and then therefore you should assume she was scared, which is why she did all of this. Is that what you're planning on doing?
No. And what you're describing is sort of the circumstantial evidence that the state is presenting for this entire trial and asking the jury to make inferences and extrapolate the evidence to come to the conclusion that Ms. Andrews is guilty of these crimes.
Well, do you have any case law in point that allows you to do what you're asking to do?
That allows a witness to testify about what they witnessed? And the case law is relevant. Give me a second.
Okay, state what's your response.
Judge, first of all, do not open the door. That Mr. McClimate specifically asked on cross-examination of the detective whether or not they asked her if she was fearful of any of her co-defendants. That was brought up by Mr. McClimate. As far as, again, these witnesses, Joel Jordan and Jacayla Robinson, they did not witness any of the abuse between the defendant and Isaiah Chance. All that they had was information that was relayed to them after the fact by the defendant. And the time period for that was months before this. In fact, most of it they could not give a time period. I think the earliest or the latest that they could give was sometime in April for when they last saw, I guess, a photograph or saw her on some sort of FaceTime. So, Judge, our point would be that it does go to relevancy at this point. There is nothing, if we're talking specifically about her state of mind when this homicide is occurring, they have no knowledge about that whatsoever.
Okay.
And so that I could finish. An individual that speaks on what a person has been through with an individual, it's linking up evidence. So, of course, they can't speak to the state of mind of an individual, but if an individual is going through something with another individual, and that relationship that the two of them share will show a different type of relationship than what the state is painting, which is that these people are really so in love that Alicia Andrews would do anything for Isaiah Chance, then that is relevant. Like, it should be allowed to come in that that's not the relationship that the two of them share. So I don't intend on saying or asking the witness, hey, do you think that Alicia Andrews was afraid of Isaiah Chance on the day of this murder? Right? If she's afraid of Isaiah Chance a year before all of this stuff happens, if she's afraid of him a year before it happens, it seems as though the state is saying that if it wasn't on the day of, if she wasn't afraid on the day of, or if we don't have proof that on the day of she's afraid of him, that evidence from the week before, the month before, has no bearing on anything that happens after that. So it's like you're only afraid of somebody for one day, and after that you get over it, and you're no longer afraid of that person. The abuser stops for 1 second or for 1 minute, and you're just fine. Everything is okay with you and him, and you no longer have any reason to be afraid. It doesn't work like that, and they know that it doesn't work like that. They know how the cycle of domestic violence works, and it's not to argue that, oh, because it happened a month or 2 months prior, the witnesses can only speak to it a month or 2 months prior to the actual incident in this case, and therefore that's too remote, or that doesn't have any bearing on whether she may have been afraid of him a month down the road. It's disingenuous to make that argument. So I think that even we have these witnesses that are lined up to testify, Joel Jordan and Caleb Robinson, who have known Alicia Andrews for years and know the relationship with her and her former boyfriend. Those witnesses, at the very least, should be allowed to testify about these issues, subject to any link-up with Ms. Andrews. And I don't, you're asking if I have case law. I don't know of any case law that prevents a witness from testifying to relevant evidence that they have knowledge of, personal knowledge of. So,
But they have no knowledge of her state of mind on the day of the murder. They have none. Zero. They don't know what she was thinking. They don't know why she went with the defendant to Tampa. They don't know why she handed the phone to him there in the parking lot. She don't know why she was in the car with Isaiah Chance, allegedly following Julio Foolio. So it's irrelevant. It's irrelevant. And if you're not alleging duress, honestly, it makes it even more irrelevant.
well, Judge, it's not about whether we're alleging the rest. The element for first degree murder has to do with intent, so state of mind. So that has so many components to it other than duress. So, like, it's not about duress, it's about intent. It's about state of mind. Those are two separate things. Yes, duress can be a part of
Correct. And none of
intent.
those witnesses can testify about her state of mind. None of them can.
Well, no witness can testify about anyone's state of mind, Judge. That doesn't mean that they can't testify about what they know about a relationship between two people.
Yeah, well, they can't if it's not, they can only if it's relevant, and it's not. So I'm going to abide by my previous ruling on this issue. So, and I don't know what the other witnesses are going to testify, but just a refresher, character evidence is inadmissible, except in a homicide case, in a very, very limited exception, okay? So,
I mean, all that we've had in this trial is character evidence of Alicia Andrews. Photographs of her with individuals that are, I guess, apparently have the gang signs thrown up, all these different charts, all of these different music videos, all of this association of her with all these other people that may or may not be in gangs, all of that is character evidence.
okay, but here's the thing. Listen, I don't make the law. Here's the direct law. WROBEL versus state, 410 Southern 2nd, 950. The appellant argues that a defendant in a criminal trial has the right to introduce evidence to show his good character. The court then cites to 90.404, which states when character evidence is admissible. Character evidence generally, evidence of a person's character or trait of his or her character is inadmissible to prove that he acted or she acted in conformity with it on a particular occasion, except, and one would be character of the accused, evidence of a pertinent trait of the character offered by an accused or by the prosecution to rebut that trait. This argument, however, omits the pertinent reference to section 90.405, Florida statute, which provides the methods of proving character. The statute reads, methods of proving character, 1, reputation, and then 2, specific instances of conduct. In Florida, the methods of presenting character evidence is limited to the testimony of reputation. A defendant may place in issue his general reputation for being a peaceful and law-abiding citizen. That's it.
And Judge, I don't know that we're presenting his character evidence, that's probably categorized as character evidence. Outside another case, Riviera, Slicker versus State. This is 941 Southern 2nd, 1191. It's the second DCA case from 2006, where it discusses that the witnesses were allowed to testify, should have been allowed to testify about dramatic changes that they had witnessed. Because they had known Slicker for years, and the excluded evidence went to an essential element of the state's case and to the heart of Slicker's defense. It cites another case, the C. Rivera versus State 561 Southern 2nd 536 at 539. It's the first Supreme Court case from 1991, stating that the error occurs when evidence tending to support the theory of defense is excluded. And I mean, that is exactly what will be happening in this case.
Give me those sites again. Let me look them up.
Slicker versus State, 941 Southern 2nd, 1191. The second DCA case from 2006. And Rivera versus State, 561 Southern 2nd, 536. This is the Florida Supreme Court case in 1990.
Okay, I'll look them up. Let's go ahead and get going. Your first one is going to be Mr. Howard. Okay, so let's bring the jury, and you, state will rest, and then we'll bring in Mr. Howard.
Yes, sir. One thing is resting, Judge.
Sure.
Ready, Judge?
Yes.
All rise.